of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody. Welcome to the show. Thanks for joining us. Today, we're talking about lawfully raising private capital through syndication. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, Facebook, and X, formerly known as Twitter. Make sure to go onto those channels and subscribe. We'd greatly appreciate it. You can also download our podcast, the audio version that is, on Spotify and on Apple Podcasts. Just go there, leave us a review, download the podcast for free, and enjoy the experience. With that, I'm going to turn it over to Sean, who has our legal update.
Thank you, Andy. So for our legal update today, I want to talk about proper contract documents and disclosures for a subject to sale from an investor seller to a consumer buyer. So more recently, I've been seeing some of the back end of these transactions, and I'm receiving the purchase contracts and the addendums and different disclosures or even lack thereof, and taking a look at them and realizing that they're not being done properly. Basically, whenever you're going to be selling a property on a subject to basis to a consumer buyer, there are a number of disclosures that need to be made to that consumer buyer. And then second, your purchase contract should not be a modified or attempted modified acquisition contract, an investor acquisition from a consumer seller subject to. Instead, the contract should be designed for a disposition from a seller investor to a consumer buyer. And then you should have a subject to addendum whereby the consumer buyer goes through and basically acknowledges all of the terms of the financing, number one. And then second, they acknowledge all of the different risks involved in the transaction. Risk would be the due on sale clause. A risk would be that the seller investor who's taking seller carryback financing fails to pay the underlying, loan obligation and what that would look like. A disclosure on insurance, and basically making sure that your consumer buyer fully appreciates or understands what it means to take title subject to. Instead, some of the contracts that I'm seeing are basically, it looks like it's just a straight seller carryback, whereby the consumer buyer is agreeing to terms of whatever the seller investor has agreed to. And maybe they're even doing it with, using in compliance with Dodd-Frank and using an RMLO and doing all of that. But it looks like a straight seller carryback as opposed to a subject to transaction. So the consumer buyer isn't even fully aware of or appreciating the fact that there's this underlying mortgage that's out there that's going to remain against the property when they acquire it. And you need to make sure that this consumer buyer understands it, appreciates it, knows the risks, is given the opportunity to have counsel of their own choosing if they want to advise them of the nature of the transaction. Because otherwise you're going to end up, closing the transaction without those disclosures. And then if all of a sudden there's a due on sale clause issue, or the seller fails to pay the underlying mortgage and you end up with a foreclosure situation, or the buyer is obtaining insurance, and then all of a sudden the underlying lender is not accepting that insurance and they're paying double for insurance, you're going to have issues on your hands. So you want to make sure that everything's fully disclosed up front and that the consumer buyer fully understands and appreciates the nature of a subject to transaction as opposed to a straight seller carryback financing transaction.
All right. Thank you, Sean, for the legal update. With that, a few announcements for you, the viewer. We have the Creative Finance Collective this afternoon at 3 o'clock Arizona time. What is the Creative Finance Collective? That is a collection of lawyers in the space of creative finance that get together weekly to talk about what they're seeing in creative finance, what they're doing, laws that might be changing, and how they're confronting creative finance issues within their respective jurisdictions. What we also do throughout that hour of time that we spend together is we take questions throughout the entire hour. So this is really a massive opportunity for you, the listener, who, if you've been interested as an investor or an interested real estate person wanting to get involved in creative finance, subject to transactions, this is a time to have captive lawyers in the space, lawyers from a variety of different states, Arizona, Texas, California, Florida, Ohio. They kind of span from all over the place that are getting together and are there to answer your questions. So if you're there and you've got time, certainly you can watch it after the fact. It'll be on YouTube, Facebook, and Twitter, now known as X. But if you want to experience it live, ask questions, and engage with the attorneys in the space, we'll be doing that again, 3 o'clock Arizona time today, every Tuesday. So be with us and make sure to do that. We're also, today's show is, we're talking about syndication. So we're taking any questions that you have. So how can you post a question? Post it in the comments on whatever platform that you're watching on today, and we're monitoring that. Feel free to post it early so you don't forget about it. We're monitoring that. We'll try to take those questions and answer them in the final 15 minutes of the show, if there are any. With that, we're going to go ahead and get into our topic today. So we're talking about raising private capital in the context of real estate, specifically through syndication. And with us to discuss that topic is attorney Paul Vincent. Paul, thanks so much for joining us.
Hey, what's going on? Thanks for having me, guys. Appreciate
Yeah.
it. And good intro. Always learn stuff from you guys.
Yeah, happy you enjoyed it. And we appreciate you taking the time to be with us. So you're an attorney with Vincent Esquire out there way over in Ohio, far away from us. Tell us about your practice and what you guys do.
Yeah, appreciate that. So yeah, we focus on kind of the entrepreneurial experience. Most of our clients are people that are buying things they can't otherwise afford themselves. So they do a syndication, they help take down deals with other people's money. We also help people with when they acquire things, what do they do with that stuff? So we help them with estate planning. So on the acquisition side, it's usually commercial, multifamily buildings, commercial buildings. And then on the business side, we help with the same thing, similar paperwork, same idea. But yeah, that's what we're spending most of our days doing.
Awesome. So one of the reasons we wanted to talk about this is raising private capital is nothing new. It's been going on for some time. There is some popularity to it right now in light of the fact that lending is so expensive. Because,
Sure.
of course, raising private capital is not the only way to come up with money for a deal. Conventional lending is the way to do that, but that's so darn expensive. So let's talk about the raising private capital side of it, and what you mentioned, syndication. Specifically, that's what we wanted to talk about today. So for the viewer that's watching that doesn't have any sort of experience level in real estate or in syndications generally, let's just start at the beginning. What is a syndication?
Yeah, so it's finding something that you can't pay for yourself and then using other people's money, typically more than one person, to take that asset down to purchase that thing. And there's going to be some compliance you need to handle as far as the legal side of things. Back in the almost 100 years ago now, when we had the Great Depression, people were selling investments that were total scams throughout the United States. And then we, our what number president was the FDR? I should know that. I don't. But he came up with the Securities and Exchange Commission to help police those types of transactions. So when you're raising money from strangers, first, you need to know what you're doing. You need to know the asset class. You need to know how to operate these things. And then second, you need to make sure that you have a team put together to do it properly so you don't get yourself in a bunch of trouble. So,
Hey, Paul. So I always hear these different terms bantered around, and maybe they all mean the same thing, but some people call it, syndication. Other people call it venture capital. Other people call it, raising private capital, having a fund, those types of things.
Right.
Can you kind of break down, like, are those terms basically just the same thing, just called by a different name, or are they different?
Yeah, I mean, venture capital has its own kind of mechanism for raising money on the compliance side and the contract side of things. But when people say a syndication, that's typically a focused plan on one particular asset. So you're going to syndicate purchasing a pet company. You're going to stack money and buy a multifamily real estate deal. That's typically a syndication. A fund can be that same thing. Those words are typically interchangeable, but often a fund is for a general purpose. Like, hey, I'm gonna start a fund to lend out money, hard money loans to single family flippers, or I'm going to start a fund that invests in commercial real estate. So it's kind of like an open end where you describe in your fund, like, hey, I'm going to buy, multifamily commercial real estate in the Phoenix market. You give me money, this is the plan we'll do with that money. This is the equity you may acquire with that money in the company. So yeah, there are a lot of terms that are interchangeable. Sometimes they're different, but as far as the difference is really like the mechanism on how you're able to raise and who you're able to raise from and that sort of thing.
So is it accurate to say a syndication is limited to one particular project or asset versus a fund could be that, or a fund could be for multiple investment opportunities and just having the funds available and investors there who have already invested for you kind of have more discretion with a fund? Is that,
yeah, people
accurate?
Yeah, people use fund often for raising money for a particular deal. Syndication's typically for used only for a particular deal. You don't really say, hey, I'm going to start a syndication to give out hard money loans. You certainly could. It doesn't really matter. It doesn't have any practical difference as far as your lawyer doing the work. But that's pretty common. Is if it's a fund, it's typically an open-ended idea with a plan in place to pursue something like buy storage in the Midwest or, that sort of thing.
So in the real estate context, Paul, a syndication would have the idea of a specific piece of real estate with, a unique address with an exact purpose on what they're going to do, whether it's flip it or rezone it or do something to that effect, but that it gets that specific.
Yeah. So, syndication, let's say hypothetically, and this is something anybody who wants to watch a webinar, we have a free webinar. It's about an hour long. It's syndicationedu.com. And it's just me and Adam rambling about a particular deal, giving some context to that deal, how that deal was structured, how the equity was sold, and that sort of thing. So syndicationedu.com. But yeah, it's like, hey, we're going to buy this 100-unit building. It's at this address. These are the risks of this building. This is the business plan of this building and how we're going to, add value to it. So when you give us your money, this is what we're going to do with your money. This is our plan to get you all or at least most of your capital back at some date projection. And, this is what we hope to do with it in the next 5, 10, or infinite years. But it's about that particular deal and how you're going to use their money and what they get for that money and how you're able to market them and how you're able to sign them up to get part of the deal.
So let's talk about entity structure then with a syndication, right?
Sure.
I mean, can I go out as a sole proprietor under my name and say, hey, I'm going to syndicate, put money in my personal bank account, or do I have to have, an LLC or a corporation or a limited partnership or a trust? What does it look like from an entity perspective for a syndication?
Now we are in the land of the free, so you can do anything you want. But yeah, so you wouldn't want to. You couldn't syndicate a deal where you're the only title owner. Now, arguably, you could say, well, I'm on it personally. Then we have a tenant in common with us that's bringing some money to the deal. Sure, you could do that. But very typical structure is the property owner would be the borrower, and that property owner is typically the syndicated LLC. So it's, INREM LLC is the property owner for this 100-unit building, and INREM LLC is cut up amongst you two, me, so we're 3 guys on it, and then maybe we're going to go get 5 investors to go give us 100,000 a piece to take it down. So there would be 10 of us in that LLC as the member owners of that property owner. So you could certainly own it in your own name. You probably wouldn't syndicate it in your own name. A typical syndication is there's an LLC that's the borrower and property owner, and then that LLC is made up of the investing members and the members that are going to run the day-to-day operation.
Now, I have clients who come to me and they've gone through some asset protection and different seminar, and they're like, "Oh, no LLC. I want limited partnership. That's what I want, and that's what I'm going to use for, all my business ventures and syndication and whatever else." Talk to us about the difference between an LLC or a limited partnership. Does it matter for syndication purposes?
Typically, banks like LLCs because they're very forgiving. They can be, managed day to day very freely. So I always recommend people doing an LLC. The only time I've ever seen an LP for a syndication is because the guys were out of Canada. So that's how we needed to do it for them and their fun double taxation. But yeah, the difference mainly can be the liability down the road. So if you're an LP in an LP, you're only at risk of the money that you put in. At least check your local counsel to confirm all this. But an LLC, arguably, since you're an active member, you could be on the hook for bad acts personally if you did it improperly for whatever that value could be. So I think that's people's idea. I will say, just as a side note, people often overcomplicate, I think, asset protection. It's like 2 things for me on asset protection. First, insurance. Insurance wins the day under any weird, complex, overly sold lawyer idea for asset protection. Insurance wins by miles every single time. So have really good insurance, a really good insurance agent to help you with that. Make sure they know what they're doing and make sure that you're protected on the insurance side. And second, be a good landlord. Think of these people as humans that are paying you every month to live in your asset. It is their home. It is not a unit. It is a place they're raising their children. So if you give a hoot about your tenants and you have good insurance, that will go a long way. I'm not a big lawyer, asset protection, complicating land trusts and everything else. Like anybody that gets bank financing, and this isn't a slight, although it will sound like one. Anybody that deals with banks and has to get bank financing, sometimes they don't understand like LLC membership and who's who and what's a manager and why is who doing this, So trying to unwrap like a complex LP land trust structure, I just don't think it's worth it. So,
yeah, and it's good to hear that because sometimes I, kind of take the same position with clients and. They're like, what, why so simple? And because they've gone to these seminars where attorneys
100%.
who are going to charge them, tens of thousands of dollars.
Tens of thousands of dollars for them to usually. So I've had probably in the last 6 months, 5 to 10 people that have spent that tens of thousands of dollars. And it's fine to get it set up. But now what? That doesn't come free. So they end up not using it. It's like, well, that was silly. So insurance wins the day. Have a normal person that you're talking to that's been in the business a while, and they'll give you the best way to do it.
Paul, so let's talk about investors. Are there a particular number of investors needed before it's considered a syndication? What does that look like?
Well, a lot of folks are like, well, if you have one investor, then you don't need to worry about it. You can just do a joint venture. One person brings the money, one person does the day-to-day, and you're free. So for me, and this is self-serving, on the one investor side, I think if there's a significant amount of money invested, then you should do the syndication anyway, because you want this investor, unless this investor is your mother or uncle or best friend or someone that, for all intents and purposes, would never sue you if it goes poorly. I always think it's a good idea that if somebody's paying you $500,000 to $1 million, or even up, even $250 to and more in a deal, syndications, for me, I suggest people to look at them as more of an insurance product as anything, because They're a CYA document for you that is putting the deal together, that is quarterbacking the deal, that is putting that money at risk. So you hope it's a bit of a waste of money, like most insurance products, right? Like you pay for life insurance and you hope it's a waste of money. You get this liability coverage and thank the Lord I didn't get sued. Nobody would want that. So you do these syndications to help ensure that if it goes poorly, which we just went through 2 years of difficulty, many deals went poorly, that somebody isn't going to be like, hey, you never told me that my money wasn't guaranteed. Every time we talked on the phone, you said, I will get 10% quarterly payments every year, and you haven't made a single one. When they get the PPM, a private placement memorandum, it'll say in there dozens of times that these are projections. There is no guarantee of any of these outcomes. I cannot promise you anything, and that's what I recommend. So 2 or more for sure. Now you're in a security. You're selling a security. 1, people tend to think the SEC wouldn't be as concerned about it. It's still a security. If someone's putting money in a deal with the idea of making passive income without any work, and they're relying on the work of the syndicator, that is security. So for me, I think it really comes down to who your investor is. If there's only one, but if it's a significant amount of money, just get it done anyway, because you need to protect yourself in case it does go poorly.
So we've talked that you can have as little as one person investing, and that could become a syndication or require certain disclosures. Now, are there maximum limits of investors? Do you have if you've done the private placement memorandum and you're out there selling membership interests or partnership interests or stock or whatever it is, in a privately held corporation, can you have a maximum number of investors that you can, have as members?
Yeah. So for most of our exemptions, so we do a lot of 506B and C. Those are the most common. They're the simplest compliance with the SEC. And you're only supposed to have up to 100 investors. So that's kind of a good rule of thumb. So that's something to keep in mind. If you're going to do a 506B, which means you can take money from buds and blood or people that you have a pre-existing relationship with, you can have up to 35 unaccredited investors. And those are people that don't qualify as accredited. Accredited investor is somebody that makes $200,000 a year. And there's kind of no end in sight in that on that front. They've made in the past 2 years and expect to make that going forward. Or 300,000 with a spouse or a spousal equivalent, or has $1 million in net assets. So that's an accredited investor. So you can have 35 unaccredited in a B, and then an unlimited amount up to 100 in accredited for a B, and then up to 100 of accredited in C. Now you can do some things, but I think 100 is plenty to deal with. And then if you need to do a new one, start a new one. But I always tell people, you want to make the investment enough that you don't have a ton of cooks writing you emails, every quarter about what's going on. So yeah.
Paul, you mentioned you used the term accredited investor, and some of us come to this dialogue with a good base and have an understanding for what that is. But for the folks that don't have any clue what that means, break down what do you mean by an accredited investor and when they're needed?
Yeah. So the Securities and Exchange Commission is very concerned about deals going poorly. They understand that deals go poorly. They understand that much of our country was built on risk taking, and risk taking is great when it works out, not so great when it doesn't. So an unaccredited investor is someone that they see that will have a harder time recovering from a deal going poorly. So an unaccredited investor is someone that does not make $200,000 a year, or a couple that does not make $300,000 a year, or someone that has not accumulated enough assets to have $1 million stacked somewhere, either in brokerage account or in their own, real estate equity or something like that. So typically unaccredited investors are newer to investing or haven't caught a break. Didn't have mom and dad cutting them a big check right at the gravesite. So yeah, that's unaccredited investor is someone that won't recover as well, or is likely not to recover as well, at least in the eyes of the SEC. than someone that is an accredited investor. And in the future, it looks like they're going to be making significant sums of money every year to hopefully recover from a deal going bad.
Paul, what is a REIT, or a real estate investment trust? And how is that connected with syndication, or is it completely separate?
Yeah, so it's typically a publicly traded opportunity similar to a fund, but it's at a much bigger scale. I thankfully don't have any experience creating a REIT, but that's what they are. You'll hear them on the radio. Typical to people that post their deals on Facebook for a 506c. It's just a lot more compliance, a lot more disclosure docs, a lot more interaction with the Securities and Exchange Commission about that opportunity. But it's kind of the same idea. We'll use your money to buy typically Class A assets for long-term, growth and stuff like that. So.
Okay, so a REIT, because I hear those terms all the time as well. Like, I'm going to, invest in a REIT, or this REIT is buying in this market. And I'm like, oh, okay, that's interesting. So
right. That's usually my answer too. Oh, interesting. Oh, cool.
Yeah.
Good for you.
Yeah. So, so a REIT is something that, like, we could just potentially go online, find somewhere publicly traded, and, jump in. And do we have to be an accredited investor to invest in a REIT?
Typically, no. Typically, they're set up so they can take, a minimum investment of some significance, but traditionally, it's not accredited only. It's basically you run through some, kind of like a regular consumer trade. Just like if you were to have an account with Fidelity and you went to go buy an Apple stock, pretty similar to a REIT.
Now, Paul, you mentioned, going back to the accredited investor, you mentioned a number of requirements that it has to be considered an accredited investor: the amount you make, your maybe total net worth, all those things. Is that a cumulative requirement, meaning you have to meet all of those, or is this like an or?
Yeah, so you have to make it as an accredited investor either on the income side, which is the 200,000, or on the assets owned side. So it can be one or the other. It doesn't have to be both.
So the SEC, or the Securities and Exchange Commission, is the governing body that regulates securities. Are there instances where syndications aren't subject to SEC oversight?
Sure, but it may not be in a federal agency that's going to be involved. But anytime you're raising capital from outsiders, there will be a state Securities and Exchange. Every state has their own Security and Exchange Commission too. So it'll fall under one or the other if you're raising capital from more than one investor, as long as it's defined as security. And a good rule of thumb for anybody that's like, is this a security? If somebody's giving you money and they're not going to be doing anything to get a return on that money, it's a security. So if your plan is to do that, you should talk to a lawyer and have him or her explain kind of what the best setup is. So some people are like, well, I'm only getting $2,000 from 5 people because I only need 10,000 to close this loan. Like, that's a security. But obviously you should spend a little time with a lawyer on, well, should I go spend $10,000 for the paperwork to go raise 10? That's not a good idea. So there's some other important stuff to remember for a listener is there are exemptions to having to do this paperwork, like a mortgage. If you can put a mortgage to securitize somebody's investment, then that is exempt from having to do this Reg D 506B and C stuff. So that's cool. If it's paper that can be repaid in 9 months or less, that's another exemption. So if someone's giving you a short-term loan and you're able to return it in 9 months or less, that's an exemption too. And those are spelled out in their regs, so people know that. But that's something most people don't know. The one cautionary thing I'll say is a lot of, there's all sorts of clever syndicators out there that think that they've come up with this plan that the SEC's never heard of, like stacking a bunch of mortgages from your investors, and somehow now I don't need to do the paperwork. What that usually means is that the syndicator has not educated their investors that priority is important in mortgage holding, right? So it's like, well, your first guy, like if you don't record anybody's mortgage because you're like, well, this is a workaround, the bank will never know. The problem is if it's default time, who's gets recorded first, who's now the second lien holder, and who's the 10th. So yeah, I will say that mortgages are an exemption, but very few scenarios does it make sense not to still do the paperwork.
What about on mortgages? So that there's not a priority issue where you put multiple investors on the same mortgage. Is that still a security?
Yeah, so that's one of the clever ways around it. The thing is with the paperwork is that you want to disclose that mortgage, sure, could be exempt from the paperwork, but you should probably have the paperwork put together explaining what priority means and explaining that you guys are probably going to be a second behind the bank. And the day the bank lends the money and it closes, their mortgage isn't worth anything yet, because until you start earning some equity, the bank is not overextending itself for your screaming deal. So even if you could stack it up, now that venture that has stacked the money with the mortgage, that itself is a security, right? So you're like, hey, I'm putting this LLC together. You guys all invest in this LLC. This LLC will have a mortgage against the property. But if I were that syndicator, I would spend the money to make sure that everybody's on the same page, because what you don't want to have happen is if somebody gets a little tight and they're looking for a way to get out of the deal, that they aren't like, well, you never told me this stuff. You need paperwork that shows that although you didn't read it, I did tell you this stuff in this big disclosure document that you signed off on before I took your money, indicating that you have read this stuff. So it's a CYA document. I'll hammer that home over and over. Get it done to protect yourself, because no deal is worth the risk. And if you can't raise the money, if the margins are too small to not do the paperwork properly, like, don't do the deal. Wait. Do something else. It's not worth the risk.
So, Paul, I've watched this show and I think, wow, this is for me. This is what I want to do. I come to your office and say, you know what? I haven't got my hands dirty yet. I haven't done anything wrong. I haven't done anything. Where do I start? How do you start this process to correctly form a syndication and start raising private capital?
Yeah. So first things first, there's so much content out there. Gene Trowbridge has a great book on syndication. I can't remember what it's called. I have it somewhere around here. That book is very good. Read that book. Go to YouTube. Watch my webinar. Like, there's 1,000 places to start. I suggest understanding how deals are structured before you put one under contract. And you don't have to be an expert at stuff. Just get your arms around what is it that an investor is actually buying in on one of these deals. And then from there, you're going to want to understand how to purchase a property properly. We get lots of deals that we discourage. We're kind of the dark clouds when people are like, hey, I got this thing under LOI. And we talk about it a little bit. And it's like, well, if you're to raise, $500,000, like, how much money is going to be there to cover everybody's interest? And there's just none there. So that's the next important thing is understanding how to underwrite a deal. And then from there, it's like, hey, reach out when you get something under LOI and we can get our side started. So if you're close to an LOI, make sure that you have a lawyer that will expect your call to help you with this stuff, because there is a pretty long runway to getting this done. And if you only have 60 days to close the deal, you don't want to be spending 45 of it trying to figure out who's going to help you with the paperwork and, what you're actually selling. We get lots of people, even very experienced people, that don't understand what they're actually selling, So we're hemming and hawing for 2 or 3 weeks on what equity they're selling. Are they giving a pref? Yes or no? Is it debt? So just start early. Give yourself plenty of time.
Well, so much of the time the opportunity hits, right? And then it's a rush to get it, especially with real estate. All of a sudden there's an opportunity. Yeah. We got to make this happen. How much time should an investor realistically expect that this is going to take and try to build out and plan for?
Yeah. So in our office, if you have a plan that, they're a little liquid, they're not they're not, it's on concrete. And once you write me an email that says this is the setup, that's it. There's always like a couple things that move. They end up getting another investor in, or they need to raise an extra, 50 or 100K that they weren't expecting because the bank's not giving them 75%. They're only giving them 70. But it's typically about 2 weeks for us. So if it's, there's firms out there that'll do it in 7. There's firms out there that'll not write you back. So just be ready for there to be anywhere between 2 weeks and probably 30 days to get this all hammered out, where an investor can look at your docs, can execute the docs, and wire you the money. So keep that in mind, that if you're putting stuff under contract, the 45-day thing is a ghost. Don't ever try to get the deal because you're going to tell the seller, I can get this done in 45 days. You're not going to. You got surveys to worry about, insurance to worry about. You got to get to the property. You got to raise the money. If a seller wants 45 days or less, just move on. It's not worth your stress. You're not going to probably close anyway, unless you're a superstar. But yeah, in our office, 2-ish weeks. And that's probably pretty common, between 2 weeks and 30 days. So
in Ohio, because normally when you go under contract, you do it in some LLC that you operate out of, but it's not
right.
Obviously you're not raising capital for that LLC. So then you have to form the LLC. You have to make sure that your purchase contract allows you to assign it to an affiliate, and you have to make sure that magic language is there. So a couple of questions. One is, what's the language you would want to see in a purchase contract to make sure that you can assign it to an entity that you're raising capital in? And then second, how long does it take to form that new entity, say in Ohio?
Yeah, we're fast here. If you don't spend the $99 extra, it'll take 7 days. If you spend the $99 extra, it'll be 30 minutes. So they're very fast in our town. So I don't know many states that are faster. The slowest ones I've seen have been Texas and Florida especially. So you need to give yourself plenty of runway on that side. We've had deals slowed up because the articles haven't been, filed at the Secretary of State. So yeah, very fast here. I don't know, what's Arizona like. I've done, I think
we're fast. We can do it in basically,
because
it's online filing. We can do it in the same day.
That's cool.
If you pay for the expedited, process.
All of a sudden they have extra staff with the, well, whatever, good for them. It's a cash grab, but
right.
they're in the business of making money too. So, so yeah, it can be very, very quick, but sometimes depending on your state, it can be pretty long. So,
and what kind of language do you want to see in a purchase contract that allows for, an assignment to a new entity that you're using to raise private capital?
Yeah, in a pretty typical commercial contract, there's usually a paragraph talking about this will be assigned to another entity prior to closing. We always put ISAOA, after the purchaser, which is its successors and or assigns. You can put assignee. You just want to have something that indicates that there's going to be a new owner. Separate from, we have guys that put it under their personal name in the purchase agreement and then they assign it. We have folks that have marketing LLCs and that, all they do is put stuff under contract. So it's not unusual that commercial deals, probably anything over $1 million, there's 99 times out of 100, there's a new entity that's taking it over. So
yeah, and I found a little bit of the fight on the buyer side is the seller always wants it to be an affiliate, who many times they define as, either an entity in which the buyer or the members of the buyer have some form of 50% interest or ownership interest, which may or may not be the case.
No, not often is that the case. So
yeah. And so that's always the fight. They normally do not want an open, assignment provision to say, oh yeah, you can just sign it, whoever. And so it's always a fight saying, well, we're raising capital. And so it is a struggle, but it's important to have that provision in there because I've been where I didn't negotiate the contract. Now I've been on the back end of these where the seller's like, no, we're not going to, do this. We want it under this buyer. They're being difficult and it's kind of silly.
That's really important because what happens, and in this market, it's not happening as often, but a year ago, someone will have put something under contract, and then within 7 days, some new buyer comes in, and a seller is just looking for any way to get out of the deal. So
Right.
that's really when it's important. 99 times out of 100, that probably won't be a problem. But if it's a seller that's looking for any little provision so that they can make another buck, they will execute that. And I don't blame them either, right? I mean, they're in the business of
Right.
making money. And if you don't lock it up properly, then tough break.
Well, what are some common mistakes that are made in creating syndications or being involved in syndications? Or I guess another way to say this is, what kind of pitfalls do you most commonly see that people should be aware of?
Yeah. First, raising money is a lot harder than you think. There are lots of deals out there. No one's going to be as excited about your deal as you are. So if you haven't started talking to people before you need their money, you're going to have a really hard time raising capital. So that's the first thing. Raising capital, way harder. Doesn't matter how long you've done it for. We have folks that we help all the time that are still raising money down to the wire. That just is what it is. Second,
Well, before you go to second,
Oh.
is that something you see a lot where people just really wait?
Yeah,
They
man.
wait to really start shaking hands until they've got the deal in hand,
Absolutely.
and
And
then they expect everybody to be their best friend when it's time to
no
do.
one is excited about your rocket ship deal as you are. So, oh my gosh, you're offering me preferred return and equity, you and 10,000 other people, So, you want to make sure people invest in the horse more so than the actual deal itself. They need to know that this person's someone they trust. It's very rare that unless you're borrowing the credibility of another investor, that a complete stranger is going to hand over dough. They need to know you, and for good reason, right? I wouldn't give anybody any money if I didn't know them, or at least I was able to lean on someone I really trusted, and they were like, "This guy's legit," So yeah, a lot of times people aren't starting to raise money until they're already into PSA, and they're like, "Okay." Like we get all the time, like people are like, "Well, what do you think I should offer?" And I'm like, I don't know. Your investor pool is not mine, so I don't know, But then we talk about it. But yeah, if you're asking your lawyer, "Hey, what do you think I should do here?" Like you're behind the gun here. So.
Then you were gonna move to a second
Oh,
pitfall
right.
before I
Yeah.
cut you off.
The second thing, I know it's very close. Shoot. Raising is harder. Oh, generosity. So if it's your first deal and maybe you have a mentor and he only needs to give away 20% of his deal or 30% of his deal, and you're like, I'm just going to mimic what he does or she does, that doesn't always work. So on your very first deal, you need to be overly generous. You need to be making as little amount as possible to prove to your investors that they're the priority. So we see often people are like, "Oh, I'm going to give away, low preferred return and a little bit of equity," and then if the deal works out, typically they flipped it where it's like we're going to give, we're only going to give away 20%, but then by the end it's like actually we gave away 80% and we kept 20. So that's the other thing is the thing when you're syndicating and raising money from anybody, it's all a financial picture. So it's like you got to put the numbers in on what your projections are and then keep moving that around until it makes sense and would be attracted to an investor, because that's all you're doing here is selling a plan to an investor. If it's not not looking strong from the gate, they'll just move on and wait for another deal. There's lots of deals out there. So
How important in your mind is it as somebody new that's trying to get involved in raising private capital to work with those that have done it before,
yeah.
kind of mentor on be a smaller piece on bigger
For
deals?
sure. Yep. Yeah, smart folks find a team, find guys that have their own network, give away, a part of their company to these guys, because you really do want to learn from these people. Single fams, you could certainly make it, a single person sport, but it's a team deal in commercial. So if you're not going to talk to the investors yourself, talk to the people that have done other deals that hopefully you can invite on your team, and they can help you get it to the finish line. And lots of people never get a deal done because the first one failed and then they just drop it all together, because they either owe somebody money, maybe some earnest money didn't come back to somebody. So now they're like, great, I owe this guy 75,000 because the money went hard and we couldn't close. So don't be that person. Be overly generous, give it away to people that have been successful. and learn, and then you can start eating up more equity yourself.
So that's kind of the practical side of getting the deal done and closing it, and pitfalls relating to that. What about legal pitfalls? What are the kind of the most common legal pitfalls you see people fall
Um,
into because they are trying to raise
yeah,
money, they do it wrong?
yeah. I mean, just not doing the paperwork puts you in a jam, because life happens where investor gives you 100,000, then 30 days later they're like, "Hey, I want out," and then you're like, "Well, I've already you know deployed your money into the deal. I can't get it back." If they weren't aware that you were planning on using their money for 24 months, or you can't point to something saying that you're going to use their money for 24 months, the best you can do is replace their money, and then pray that they don't report you for not having your disclosure doc. So that's the most obvious one. Is we get lots of people that are like, "Oh, it's a JV," and it's like, "Oh, cool. Tell me about that." And they're like, "Oh, we got 10 people giving us money." And it's like, well, are they going to be doing anything today? No, but they want to keep an eye on the deal. And it's like, no, that's a syndication like anything else. So um, that's a pitfall. Thinking that you've thought of something that thousands of other syndicators haven't. Everything's been thought of. You're not going to cute your way through some new mechanism. So just do it right. Talk to somebody that knows what they're doing, and spend the money.
All right. Do we I couldn't read our comments. Do we have any questions, Sean?
Yeah, we do. So, Mayu, if you want to post those so we can see them on the screen, that would be great. But I saw one come through on our private chat. So yeah, here it is. Can you bring somebody onto your team just to raise private capital in a syndication?
Yeah. So two answers: yes and no. So you're not allowed to bring someone on and pay them a commission. A commission is cash or equity, unless they're a licensed broker dealer. So no, in that instance. So if you've already got your syndication started, you're about 3 weeks out, you're panicking. Some guy says that he can raise money for you, and you're like, okay, cool, I'll give you some of my equity. By law, no, you're not allowed to. But after this podcast, now you're like, shit, I need to go make a team. You can go talk to this guy before you get a contract and say, hey, let's go do some things together. That person has been part of the company from the outset, so they're not getting paid equity for that particular deal. That's just one of the roles. Everybody's role in a syndication is to raise dough. So you're going to want to have that conversation with the capital raiser well in advance of a deal. They need to be part of the deal from the outset, the discussion from the outset, the plan from the outset, and then you're going to be okay. But if you're bringing them on a couple weeks before closing, you've done it wrong, and you have some risk for both of you. So,
yeah. So if I understand what you're saying correctly, is there can't be a quid pro quo. You
right.
get equity if you raise, this amount of money for us.
Sure.
It can't be that. But if, hey, I know this person and they're great at, raising private capital and they have the connections and things like that. And I go to them and say, hey, look, I'm going to form this LLC. We're going to go after this property. You want to be part of the transaction, and I'm going to give you X amount. And then, our roles are going to be this, and that. And, part of your role, part of my role is going to be raising private capital, but you don't put like, hey, if you raise this much, you receive this much, right? It's just simply like, here it is. And now let's go make some money. That's probably going to be.
Yeah. And that actually
right?
goes back to one of my pitfalls is you're partners with these people for years and years and years. Like, know these people before you jump into a deal with them. So that's why those discussions are important now, because you need to spend time with these people. You need to look at deals together. Maybe you need to make sure that both of your goals are the same. So we've had a couple deals where it's like one partner wants to sell and get rich. Another partner is persuaded by this legacy stuff, and they're like, oh, I want this, legacy income for the rest of my life. And the other person's like, I just want to sell and make $300,000 and be rid of this thing. You want to make sure your partners are aligned on the plan. So that's an important reason why having these discussions early will help you. You'll close a lot more deals if you have these, teammates in their particular roles, part of the company. So you don't need to. You can certainly have like an LLC with these folks, and that will hold your guys' equity. But if it's someone you spend time with and you can trust them, you don't need to formalize it right out of the gate. You can do it for the particular deal. But if you're like, oh, I don't know that I can trust this person, do not trust this person and do a deal with somebody else.
Well, and that actually raises an interesting issue, which, we're talking about preparing the documents necessary to have the proper investment disclosures and SEC compliance and state law compliance. But talk to us about the importance of having a well-drafted operating agreement as part of the transaction, because you mentioned, hey, look, you may have two investors who you want both of their funds, you want both of them to invest, but one has an interest in the long-term income, and the other one just, hey, they just want to flip it. They just want their, they want in and out, and they want it in and out quick. In my view, a well-drafted operating agreement with certain, buy-sell provisions could allow for both of those interests to, mesh. But if you just go find an operating agreement online or, off the shelf from somebody who's offering it out there, and you fill it in and you don't go to an attorney and say, okay, look, I need to make sure that, this investor can hold for as long as they want, and this investor can, sell their interest. I think you're going to be in trouble. So, talk to us about your role too, as far as, drafting operating agreements and making sure you get those in place so that you can meet the needs of, the different investors.
That's right. Yeah. And, and there's, a syndication LLC is much different than the Law Depot version, that we can all get off the internet. So those are important. You need to know, like, hey, what happens? What's the plan when one of our investing members passes away? Are we just transferring their membership interest to their estate or their trust? Or do we actually have to pay them out? Many operating agreements will just say, oh, you got 90 days to pay them, their capital back and some, valuation, which is like, oh, we can't do that, So yeah, you want to pay attention to those things. You want to make sure that there's provisions in there to cover the scenario where you got to kick some bad actor out. Like what happens, in that scenario? Do we actually have to, if someone misbehaves, do we actually have to pay them 80% of the valuation of their interest? So there's stuff in there for that. But yeah, you want to make sure you're talking to someone that's done these before, because they will tell you like, hey, if one of you wants to sell, what's the plan? If the other one wants to not sell, and he or she will be able to walk you through.
So as part of your syndication process, the drafting of such an operating agreement. Okay.
Yep. So and we have stuff in there like, hey, and it's usually post-close, like, hey, if any of these members have, a trust that they want their membership interest to transfer to, like, just let us know. We do a simple resolution and, it sits in the books. That's pretty common. But yeah, it's something, and going back to like what we do day to day, most people don't think about what happens to my membership interest when I pass away. Do you have any bias? Like if you have a bunch of deals, my brother and I, we own a firm together, right? So it's like, yeah, when one of us dies, we don't want to have to pay the estate off of whatever this thing's worth. So we just have life insurance, so right. Something we talk to people about often is this key person insurance. And if one of you goes away, like how do you pay off the estate of the other? If you're part of deals and you don't have an answer to that, use this podcast as a reason to go talk to an insurance agent about it.
Sean, did we have any other questions?
No, I think we covered syndication.
All right. Well, Paul, thank you so much for being with us. Tell our listeners how they can connect with you.
Always a pleasure, guys. So if you guys have a deal or you just want to chitty chat for a couple minutes, if you go to dealdiscussions.com, it brings up my Calendly. Pick a time. Happy to talk to you. Happy to walk you through this same sort of rambled mess I just did. If you have your own deal and you want to think about like, hey, how do I do it? So dealdiscussions.com. If you want to watch a webinar, it is syndicationedu.com, and that'll show up. You give us your email and your name, and you'll get access to our Google Drive that has our webinar in there. So thanks so much for having me, guys. I'm obviously on Facebook. If you guys, follow me or send me a message, happy to talk to and set up a time. But really appreciate you guys having me back again, and look forward to next time.
Yeah, awesome. Paul Vincent Esquire, thanks so much. Look forward to doing it with you again.
Thanks, guys.
All right, talk to you soon. All right, with that is our show. Make sure to join us next week. It is Are You in the Driver's Seat Buying Commercial Property Subject to with our friend Jeff Watson, also up in Ohio. Make sure to join us next week. We'll see you then.
Have a good day, everyone.